I think we have all the judges. Participants are also there. So I'll just do a quick introduction of all the judges for the benefit of the participants, and then I'll hand it over to the court master for the instructions regarding the rounds. So thank you to all the judges for taking out time on a Sunday morning and adjudicating the semi-finals of the annual Intra-Departmental Moot Court competition here at the Department of Law, University of Calcutta. So we have 4 judges for semi-final number 1, and I'll just introduce everybody one by one. Our judge number 1 is Mr. Jaideep Singh Khattar, who's a partner at the 4th Circle Advocates and Solicitors, and he's ex-principal associate at Khaitan & Co. Our second judge is Mr. Nipun Saxena, who is a practicing advocate in the Honorable Supreme Court of India. Sir also takes up various matters in the high courts throughout the country, also along with tribunals and other quasi-judicial authorities. Thank you, sir, for joining in. We also have Mr. Ranjit Lakmani, who is a counsel practicing at the Honorable Calcutta High Court. Sir is also a member of the Bar Library Club at the Calcutta High Court and is also a visiting lecturer at WB and UJS. Thank you, sir, for joining in. We also have Mr. Dr. Vishwa Kalyan Das, who is an assistant professor of law at Kalinga Institute of Industrial Technology. Sir also was the ex-research head at the Center for Artificial Intelligence and Law, and Sir pursued his PhD in law from WB and UJS, Kolkata. Thank you to all the judges who took out time on a Sunday morning, and without delaying this further, I would now request the court master to take this forward and instruct the judges and the participants regarding the intricacies of the rounds. Thank you so much. Court master, just one more thing. So once the judges have finalized their decisions, once the round is over, there's a room called Judge Rooms Lobby 1, where judges can actually go and discuss privately if they want to discuss something and deliver a unanimous verdict, in case they do not want to mark it on the score sheet. So that is also acceptable since this is a knockout round. So it's on the judges if they want to mark it or actually pronounce the verdict privately to the committee, and then we can actually announce it to the participants later. Thank you. Thank you.
Okay. Thank you, ma'am. Welcome, Your Lordship. Welcome all the participants. I will just quickly read out the rules of the competition. Okay. So all the participants are hereby informed that each team will get a total of 25 minutes speaking time for the semi-finale round. Both the teams can divide speaking time between their both speakers at their own will. Petitioner, if opting for rebuttal, will save the time for the rebuttal in the provided 25 minutes only and will not be allowed and will not be provided any extra time for rebuttal. Respondents in this moot court competition are not allowed to make any self-rebuttals. From the commencement of the round till the round is over, all the participants, including researchers, must keep their video feed on and under no circumstances will be allowed to argue if all team members' videos are not visible. In the case of audio, all the participants should keep their microphone off except during their speaking time or if they are directed otherwise. In case of a network connection issue or technical glitch being faced by a participant, he or she will be given a window of 5 minutes only to solve their problem. And if the concerned participant is the speaker and he or she fails to join within the stipulated time period, the other speaker shall take over thereon, and in case both the speakers fail to join, then the researcher can take over only after taking permission from the respective judges. From each team, only researcher can share the compendium via screen share mode only, subject to the discretion of the judges. That's all, Your Lordship. The petitioner counsel will now begin with the submissions. Thank you.
Good morning, Your Lordships. Permission to approach the Honorable Bench?
Yes, go ahead.
Much obliged, Your Lordships. Are Your Lordships well versed with the facts of the case?
Yes, we are. You may proceed with the issue.
The Honorable Court has jurisdiction in the present matter under Articles 32 and 136 of the Constitution of Georgetown. Now, proceeding with the issue, in the landmark case of Navdeep Singh Johar versus Union of India in 2018, the Supreme Court of India, while decriminalizing same-sex relations, had observed that while evaluating a law for constitutionality, what is not important is the object of the act, but what is important is the effect of the act.
Sorry, if I may, I'm really sorry. Could you just tell me what your prayers are? What do you seek?
We had planned to say the prayer at the end, but nevertheless, the counsels for the petitioner herein has divided the issue up between the speakers. And the first issue here, the problem of the moot, is we have challenged the constitutionality of the recently enacted Georgetown Freedom of Religion Act. This is the first issue. And the second issue is that we have challenged the rejection of the bail application of the petitioner herein, which was rejected by the Honorable High Court
Counsel,
of
the
Queensland.
prayers, not the
Yes.
issue.
We humbly pray. What we humbly pray is that this impugned act, the Georgetown Freedom of Religion Act, be declared ultra vires of the Constitution of Georgetown. And
Any particular provisions that you want us to highlight? What particular provisions of the act are you impugning?
we will highlight that along the way, but we'll also actually our prayer is ultimate prayer is we want the whole act to be declared ultra vires, and we will show along the way why that should be done by the honorable bench. And our second prayer is that we pray for bail. We challenge the rejection. We challenge the rejection of the bail application of the petitioner, and we are praying for bail of the accused person here. Permission to proceed?
So essentially, just hold on a second, please. So essentially, you're challenging the wires of a constitutional provision, and in the same petition, you're impugning an order passed by the court below, whereby bail was rejected. Right? Could you just place the impugned order before us?
The impugned order regarding?
Is there an operative part of the impugned order?
Yes, as for the facts of the moot problem clearly has stated that the Supreme Court, the Honorable Supreme Court of Georgetown, by exercising its jurisdictions and extraordinary powers, has clubbed the two issues, and today the two issues are listed for final hearing.
So the question is that the lower order, the order of the lower court, what is the operational part of that order? The order that you're challenging, the bail order of the lower court that you're challenging, what is the operative part? That's the question from my brother.
The High Court of Queenstown, while rejecting the bail application, has stated that bail should not be given to the accused person here because there is no reasonable ground to believe that the accused has not. The court believes that the accused has. There is no reasonable ground to believe that the accused has not done the offense. The court believes that the accused has indeed done the offense. So based on this, the High Court rejected the bail application.
Counsel, are those the exact words? We would like to draw your attention to paragraph 7 of the compromise. Because it doesn't appear that the High Court says that we have reasons to believe that you have committed the offense. So please do not misquote the impugned judgment.
Sorry, Your Lordship. Sorry for that, Your Lordship. As per the moot problem, there are no reasonable grounds to believe that the accused has done the offense. So the accused should not be released.
Could you just screen share? Could you just screen share the operative part of the impugned order for our perusal, please? Some colleague of yours, maybe your instructing solicitor, could you just
the respondent is the researcher is requested to screen share the relevant portion of the moot problem, para 7 of the moot problem. The researcher, please, if you may.
Counsel, while
just a moment, please. Just a moment.
Yes, Your Lordship.
Sorry, I was asked to hold my query.
No, absolutely not, Your Lordship. You're the king here, Your Lordship. Absolutely not. Please go ahead. Yes, Your Lordship. You had a query. You had a question.
Nothing. It's all right. We'll wait for your screen share now.
Mr. Counsel, if you could just refer to your written submission on the paragraph on the fact sheet, that is page number, I guess, 6 at paragraph 9. You have mentioned all these things, right? The rejection point of the High Court.
Yes, Your Lordship.
Could you highlight on the part why are you approaching this court? On what point, when it has been clearly mentioned by the High Court on paragraph 9, what you have recited?
Actually, your lordships, if your lordships deem fit, we had planned in our argument that to maintain the flow of the argument, we would first challenge the constitutionality of this act, and thereafter we will seek the bail. So, if your lordships permit,
as you should, please proceed with the arguments.
As well, if your lordships permit, may I proceed with the argument? Thank you. Much obliged, your lordships. So, as the council was stating earlier, in the landmark case of Navdeep Singh Johar versus Union of India, while the Supreme Court decriminalized same-sex relations, the Honorable Court had observed that for evaluating a law for constitutionality, what is not important is the object of the act, but what is important is the effect of the act. The counsels for the petitioner will step by step show how this Georgetown Freedom of Religion Act violates, in effect, the golden circle of the golden triangle of fundamental rights and other fundamental rights of the citizens of Georgetown. Also, it would also go on to show how the Central Parliament of Georgetown has legislative incompetence to make a national anti-conversion law, and also how this act goes against the principles of transformative constitutionalism in this 21st century. So, proceeding with the violation of fundamental rights. Attention is drawn to Section 2, Clause C of the Act, where the definition of conversion has been included in this Act. This definition of conversion in this Act, your lordships, clearly states that the definition of reconversion is left out of the ambit of this Act. Your
Counsel, I'm so sorry to break your flow, but the moment you have raised as your preliminary submission a ground of legislative incompetence, then ideally you should attack that first and then come to the provisions, because you have said that the parliament does not even have the competence to enact such a provision.
Okay, your lordships. We'll go forward with that. We actually thought of doing it later, but as the honorable
counsel, jurisdictional questions have to be raised.
Exactly. We are sorry for that.
Counsel of your standing must know it.
Extremely sorry for that. So, to begin with the legislative incompetence of the Act, legislative incompetence of the Union of Georgetown in passing a national anti-conversion law, the councils beg to state relevant portion of the landmark judgment of Reverend Stanislaus versus State of Madhya Pradesh, where the Supreme Court, the Honorable Supreme Court, had observed while dealing with an anti-conversion law that the Central Parliament does not have the legislative competence to enact a national anti-conversion law. Now, it may be contended that this landmark judgment was about older act of the Madhya Pradesh Dharma Swatantrata Act, which actually got repealed and replaced with the new act of Madhya Pradesh Freedom of Religion Act of 2021, which is pari-mixture with this Georgetown Freedom of Religion Act. In this regard, it is humbly stated that it got repealed, the old act got repealed, but the observation of the Honorable Supreme Court is about whether national anti-conversion law is tenable or not. The new act, in essence, as per the doctrine of peace and substance, it deals with anti-conversion. It deals with regulating conversions and has only incidental encroachment into the domain of religion. So, as per the observation,
I have a question. Does the new act that you're challenging the constitutional violations of, does that prohibit anybody by consent from getting into an interfaith marriage? Is it that just by the mere nature of marriage itself, the offense has been committed?
Regarding that, it's a topic of violation of fundamental rights. If the lordships permit, we'll come back to this point in the later part of the submission.
Sure.
Counsel, let's go through this.
But see, that's what my brother asks is a pertinent question, because if you don't clarify these things, we won't follow your arguments at all. You see, it's not an elocution. You please address queries, else we won't follow any judgments that you cite, because we won't have a factual elements in our heads.
If your lordship may be kind enough to repeat the query which you just stated.
No, so the query that I have is that, are you saying that the new act, the act which is under challenge by you, the constitutional violations of which have been challenged, does it disallow or does it automatically make it an offense by the mere fact that somebody who's from a different religion gets married and therefore gets converted? Is it that by choice nobody can marry, an interfaith couple can marry, right? Does the act prohibit that?
Your lordships, the attention is drawn to the very preamble of this act and section 3 of this act, which clearly prohibits religious conversions by marriage to be void. Religious conversions by marriage has been declared void by this act under section 3 of this act.
No, my question is different. Is it that just by mere marriage I get converted?
Your lordship,
religious conversion, I follow that religious conversion is not allowed by marriage. That's fine. But is it that can I still be married and can I still follow my faith? Suppose in your current problem, there is verum and there is atheism, right? So if two people are getting married, do they necessarily need to get converted? Does the wife automatically get converted by virtue of this act?
Religion is something very private, your lordship. That's totally up to the spouse.
That's right. My question is very specific. Under the statute, just by the mere fact that I'm married, does that mean that I've converted? Can I not still continue to hold whatever religion I'm holding? Does it mean that I'll automatically, my religion will get converted the moment I get into matrimony?
There are some express provisions in this. Yes,
may I just simplify it further? Let's say that a Hindu woman marries a Muslim man. So, under the act, is it an obligation upon her part to become a Muslim the moment she marries a Muslim man, or she has the liberty to continue identifying herself as a Hindu despite marrying a Muslim man? This is
yes, your lordship.
Under the provisions of the act, please just tell us, because we are here questioning the wires of the act. So kindly tell us what the act says. Please don't tell us what ought to be the thing, right? Just tell us what it actually is that you're challenging.
Yes, your lordship. In this act, there are no express provisions that say just by marriage the religion of any spouse gets changed. Just by marriage the religion of any spouse doesn't get changed. That is outside the ambit of this act, your lordships. Just by marriage religions don't change. There is nothing mentioned about this in the act, your lordships.
So are you sure you want us to strike down something, or maybe you may consider wanting us to maybe read into a provision and maybe give it a meaning which is in congruence with the constitution or the preamble, or would you specifically want us to just strike it down? Because there is a scope, I suppose, to maybe read into something if there is ambiguity, and unless it's expressly void on the face of it.
If your lordship.
Sorry, Counsel, can you please read section 3 for our benefit? Because it doesn't seem as if a conversion automatically would result into a penalty. That conversion is qualified by the words misrepresentation, fraud, undue influence, coercion, and so many other factors. Why are you selectively making a submission by, on one hand, quoting section 3, on the other hand, not telling us the contents of what section 3 encapsulates?
Your lordships, religious conversion, section 3 bans, prohibits religious conversion that have happened by force, coercion, allurement, marriage, and other things.
No, that's not. I'm sorry. The way you are reading section 3 is not how it is worded. It's not that marriage is a subset, just like coercion, undue influence. It's marriage on account of undue influence, coercion. Please read the provision for us.
Yes, your lordships. Just a moment, your lordships.
No person shall.
No person shall convert or attempt to convert, either directly or otherwise, any other person by use of misrepresentation, allurement, use of threat or force, undue influence, coercion, or marriage, or by any other fraudulent means. Your lordships, as per this provision of section 3 of this act, if suppose two interfaith couples have married, what this act does is it brings a shadow of criminality over interfaith marriages. That's what it does. Suppose two interfaith couples have married. This act has provisions in it that basically allows anyone, any member of the family members who is not happy with the interfaith marriage, or even a member of a Khap Panchayat can literally go and interfere into the marriage, whether the spouses agree to convert or not convert. It is a different thing, but this provision allows anybody to interfere within the religious conversion or interfaith marriages. So this is what we are against, your lordships. So coming back to the legislative incompetence, of the Union of Georgetown in passing a national anti-conversion law, it is humbly stated that this act in essence is nothing but a national anti-conversion law which has provision to deal with public order, to deal and maintain public order, which may get disturbed from time to time because of forcible conversion. So,
Council, why are you bringing it within public law? I think it's a simpliciter. There are particular provisions. They stipulate an offense, and there's a penalty prescribed. So to us, this anti-conversion law is sort of a criminal statute. So, and also, if you were to argue, I mean, it's squarely covered under NT3 of the concurrent list. Even assuming that it deals with marriage in some part, then it's again covered under entry 7 of the concurrent list. So to say that the parliament does not have the competence, why don't you address on this aspect? Ms. Roshni will give him extra time considering we are bombarding the council with all our queries. So I think with the consent of all my other brother judges, I think we must.
Much obliged, your lordships.
Yeah.
Your lordships, to address that particular question, according to the doctrine of faith and substance, in essence, this act is an anti-conversion law. An anti-conversion law, as we stated in the landmark judgment of Stanislaus, essentially deals with public order, maintaining public order to prevent disturbing of the public order that gets disturbed from time to time because of forcible conversion. Your lordships, there is only incidental encroachment into the topic of marriage or religion, etc., etc. So since in essence, this national anti-conversion law has been made by going into the domain of a state list matter, this proves the legislative incompetence of the act. This proves the legislative incompetence, and most importantly, this is not exactly a strong argument, but a comment is a notices of the honorable bench is drawn to a comment of the Union Law Ministry in 2015, where the Union Law Ministry had clearly stated in an interview in a report of the Deccan Chronicles that a national anti-conversion law is not tenable. So this is also a testament to the fact that the national anti-conversion law is not tenable, and that the legislature of Georgetown had abused its legislative power and violated due process of law by making the national anti-conversion law. The extreme right-wing party GDP, which currently in power of Georgetown, has done this violation of due process of law. So coming back to the violation of fundamental rights, your lordships, with your permission, the councils will show how the golden triangle of fundamental rights is violated and other fundamental rights guaranteed to the citizens of Georgetown.
Council, just 1 second. I think
yes,
we're a little short on time, so I just have 2 quick questions. One, I want to understand, you're saying that he should be granted bail, right? Now you're saying there are no previous criminal antecedents. That's right. Where are you getting that from? The facts that there are no previous criminal antecedents of the accused?
Nowhere in the moot problem it is mentioned that the accused had been charged previously, your lordships. So based on this, we are stating that there are no criminal antecedents, your lordships.
Okay. And second, on what basis are you challenging the wires of the Act under Article 14 and Article 15?
Coming to Article 14, your lordships, attention is drawn to Section 2, Clause C of the Act, where the definition of conversion has been given. This definition of conversion exclusively leaves out reconversion. Your lordships, if we leave out reconversion from the ambit of an anti-conversion law, this essentially means that conversion by marriage or coercion or fraud is illegal, but reconversion by marriage or coercion or allurement is absolutely legal. In this regard, an observation of the US Commission on International Religious Freedom Rights is to be stated by the Council.
How is it? Sorry, I didn't follow. How is it violation of Article 14?
Your lordships, Article 14 deals with the right to equality of the citizens of Georgetown. Your lordships, if this act allows conversion by marriage, or force or fraud to be made illegal under this act, but reconversion can be done by allurement, by coercion, by force, by fraud. How is this equality, your lordship?
No, I didn't follow. When you say reconversion can be done as in?
Reconversion as in, suppose a person has suffered unlawful conversion. A person has suffered unlawful conversion or forcible conversion. Now, he doesn't know it. Suppose he has been allured. He has been coaxed into a different religion. He doesn't know it, that it is not good for him or whatsoever. He has done it, and the state gets to decide arbitrarily. What religious conversion is bona fide and what is not. And based on this, the state will decide, violating Article 14, that whether he will go back to his parent religion or he will stay within the parent religion. Your lordships, if we leave out reconversion from the ambit of a national anti-conversion law, this will essentially mean that the persons who have converted, say, into the religion of minorities, a person has converted into a minority religion, he or she can be coaxed back, he or she can be coerced back, he or she can be forced back, she or she can be, by marriage, he or she can be converted back into his parental religion, and this anti-conversion law will do nothing. This anti-conversion law will just sit back and watch.
Won't it be a fresh cause of action? Won't it again then fall under Section 3 as a fresh cause of action?
Exactly, your lordship. This act, by leaving out reconversion,
why do you say it leaves out reconversion? Conversion, once you convert from Hindu to Muslim, assuming you can, and if you again do Muslim to Hindu by marriage, you still again fall foul of Section 3, no?
No, this act stops that. This act stops that from doing that.
Where do you get that?
This definition act, 2+C, in the definition of conversion.
Counsel, allow us to summarize what you are trying to say. Are you saying that this creates a two distinct category of individuals? One, where the conversion per se is penalized, versus those category of individuals where reconvertants are not penalized. Is that what you are saying?
Exactly, your lordship. Reconverts are kept outside of this act, your lordship. By leaving out reconvert outside of this act, basically anything can be done with reconverts. They can be coaxed back into the majority religion from the minority religion. This is where equality is getting violated. And coming to Article 15, your lordships, suppose two interfaith couples marry, and one spouse wants to convert into the other spouse's religion freely, voluntarily, he or she wants to convert. But this act will not only allow that conversion to take place, this act will also declare that marriage also void. This is discrimination on the ground of religion, thus violating Article 15, Clause 1 of the Constitution of Georgetown, your lordships.
But counsel, assuming that the compromise is in pari materia with the laws of India, and you belong to a religious majority, then under Hindu Marriage Act, let's say there's a Section 11, you can always claim for annulment of marriage if there is any deception, if there's any fraud which has been practiced.
Your lordships, personal laws of the country always make some marriages void, some marriages voidable, some marriages void ab initio, some personal laws give grounds for divorce. These grounds are always available.
Counsel, we are saying you already have a remedy, right?
Yes, your lordship.
We are saying that the remedy is always available to you. Are you challenging it on the basis that since there are already provisions in other laws which are there to take care of such a contingency, why have a particular provision such as one of the provisions which is there in the impugned statute, which says that all those marriages would be deemed to be null and void?
Your lordships, when a person, suppose there is a couple, A and B, they have married each other. A converts the religion of himself. That may be a ground of divorce for the B. Under the personal law. But that is a separate issue, lordship. What I am saying is A and B are two couples. They are interfaith couples. They have married each other, and one spouse among them wants to convert into the opposite religion. Say for the happiness of the family or the happiness of the other spouse. This act will not allow to do that, because this act will then say that you are converting for marriage. This act will then say that you are converting for the sake of marriage, so will not allow you to do that conversion, and will also declare the marriage to be void. So this is our humble statement that this is discrimination on the ground of religion. Your lordships, now coming to the point of, we have covered articles violation of 14th, 50th, And coming to the point of Article 19, your lordships, in the case of Asha Ranjan versus State of
Counsel,
Bihar,
I think we'll just give you another minute to summarize because I think you have far exceeded time.
May I just say one thing? I think we've gotten the essence of 142119. You tell us why shouldn't we let our client languish in jail?
Yeah, coming to that bail issue, your lordship. Usually while opposing bail, the counsels for the state give some stock arguments like there is scope of witness and evidence tampering, there is scope of fleeing from justice. So contending that, the attention is drawn of the honorable bench to the fact that this accused person, the accused husband, was arrested on the very day the FIR was made. This is a testament to the fact that the accused husband is a common man. He is a common minority man who has no power whatsoever of doing witness and evidence tampering. Moreover,
Counsel, why do you think it's unfounded an allegation that there is no possibility of witness tampering? Both husband and wife used to live together. Of course, he is known to all the relatives. How can you take away the fact that he has no power to influence at least other witnesses or material to this trial?
He has no power, your lordships, because he is just a common man. If he was influential and powerful enough to do witness tampering, if he was powerful enough to turn witness into hostile witness.
Hasn't he restrained the wife when she wanted to go back? Didn't he restrain? That's what your facts say, right?
Your lordship, that is just an allegation. There are lots of, as per the facts of the case, there are lots of counter allegations by the husband, which the police, being an instrument of the state, has not paid heed. By being anti-minority in nature, they have not paid heed to the counter allegations of the husband here, and they have just paid attention to the allegations of the wife.
So what are the counter allegations from the husband in the Moot problem?
The counter allegations by the husband is here that, your lordships, this newly enacted law has been recently passed. The wife, the de facto complainant, and the family members of the wife are just using this newly enacted draconian anti-conversion law to harass and extort money from this poor common man. Your lordship,
Counsel, is your wife a major?
Yes, your lordship.
She's capable of entering into a consensual relationship?
Yes, your lordship.
Absolutely. Then you would keep her against her will. You will wrongfully confine her. And then when she proceeds to register an FIR against you, of course, along with the parents, you would take this argument to say that, no, but she entered into this arrangement consensually?
Your lordship, as per the facts of the Moot problem, something is stated that the marriage took place. Before the marriage took place, they knew each other for 4 months. 4 months, it was not a completely arranged marriage. They had known each other for 4 months. Your lordships,
and she claims you have deceived her.
That is just an allegation, your lordship, the merits of which will be decided at the trial stage. The merits of the allegations are not to be decided at the while deciding the bail application, your
But
lordship.
you would also appreciate that for the purposes of allowing or rejecting your bail, we have to assume prima facie that all the allegations against you are true and correct on the face of it, and then proceed.
Your lordships, the concerned husband here has already languished in custody for more than 200 plus days. Trial has not started. Charges have not been framed by the court since filing of charge sheet. Your lordships, this draconian law puts the burden of proving on the accused.
Counsel, why don't you apply for default bail? If after a period of 90 days, if you are still languishing in prison and charge sheet has not been submitted, then you...
No, charge sheet has been submitted. What we are saying is charge sheet has been submitted, but the court has not framed charges. Trial has not started.
What is the date on which charge sheet was filed? When were you arrested?
We are arrested on 31st March. It was within the time, so that's no statutory bail. So that's why we didn't put that up. Your lordships, more than 200 plus days have passed in custody. He has been suffering like a convicted criminal in custody.
What is the penalty? What is the imprisonment tenure which is prescribed under the statute? 10 years?
Maximum 10 years.
Maximum 10 years.
Minimum
so
3
you
years.
Have only spent what, 200 days out of 10 years?
No, your lordships, what we are trying to say is to ensure right to fair trial of the accused, since the burden of proving the innocence is on the accused as per this draconian law, is on the accused to prove he should be released from custody under any terms and conditions so that he may prepare his case.
Are you also assailing the validity, the constitutional virus of this statute on the basis of the burden of proof?
No, absolutely not.
You are
We're
not, because
no.
because you are aware that there are so many statutes which provide for a reverse burden.
Exactly. We know that.
All right. So, but then you want us to consider that as a mitigating circumstance to grant you bail, just because there's a reverse burden of proof.
No, what we want to say is that, Your Lordship, this humble man is a common man, as you have stated earlier. He needs time to bail after he has suffered for 200 plus days. The bail was rejected in 5th July.
Thank you so much. We would like to hear the other speaker. Thank you.
And just one more argument was left. If you just...
No, it's all right, Counsel.
Okay. And regarding one more thing, it's a different thing. Away from the submission. I would like to
I think we made up. I think we heard you. I think we hear the other side, and if need be, we'll call you again. Okay.
It's not related to the submission, Your Lordships. It is something about my health issue of my lady co-counsel. She suffers from multiple tumors, non-malignant tumors in a sensitive body part, because of which she could not perform in yesterday's one of the preliminary rounds. But since before this esteemed bench, she is very eager to perform, so she will make her submission. And she also say the prayer once again, if Your Lordships permit. But in case if she fails to complete her submission, or if she fails to satisfy any of the questions, it is humbly requested that the questions may once again be redirected to the speaker one, so that we can, as a team, prove our case. That is our request.
Thank you.
Much obliged, Your Lordships.
May we please have the speaker number 2?
Good morning, Your Lordships. The counsel for the petitioner, Speaker 2, would like to begin her submissions. Your Lordship, it has time and again been contended by the accused that his wife, Sandra, was aware of his religion and had agreed to convert out of her free will, and that she and her family members were using the draconian new law to harass him and to extract money from him, and that the police did not give any heed to his statements, as has been stated in paragraph 5 of the moot problem. Your Lordship, the accused belongs to a minority community, and with the recent incidents of communal disharmony in Georgetown, as has been mentioned in paragraph 2 of the moot problem, and that inaction of the police regarding the accused's serious allegations against the wife and her family members of extortion and harassment through a string of fabricated charges, it can be deduced that this is a serious case of minority discrimination against the accused. Since the accused has been languishing in jail for more than 3 months without a trial, it's humbly played before the Honorable Supreme Court to grant him bail under any terms and conditions as the court deems fit. Your Lordship, since he was arrested on the same day the affair was registered, suggests that he has no influence in the society and is a little man, and hence there are no chances of his abscondence from justice or misuse of liberty granted to him through bail, as has been already stated by my co-counsel. Your Lordship, adequate conditions like submission of passport and weekly reporting may be granted to ensure his future appearances at the trial and safeguarding of witnesses and evidence tampering. Your Lordship, it has been stated in Kalyan Chandra Sarkar versus Rajesh Ranjan that successive bail applications must receive due considerations in the hands of the court. Hence, as in the present case, on 5th July 2021, the bail application has been rejected.
I'm sorry. Could you just give me the citation, please, of the judgment that you're relying upon?
Just a second, Your Lordship.
We apply to the facts. Just let us know the judgments you're relying upon, please, with the citation.
Just a minute, Your Lordship.
And the proposition and the relevant paragraphs.
Your Lordship, it has been mentioned in paragraphs 41 and 42 of the memorial.
Sorry, memorial?
Of the petitioner memorial. Yes, Your Lordship.
No, are you relying upon any particular judgment? You refer to a judgment. Yes.
Yes, Your Lordship. Yes, Your Lordship.
Is it a reported judgment?
Your Lordship.
Or is it an unreported judgment? Which court is the judgment of? Is it a High Court judgment or a Supreme Court judgment?
Supreme Court judgment.
Is it reported? It's a Supreme Court judgment. Is it reported in any journal? AIR, SCC?
Yes, Your Lordship.
Yes, please give me the citation, please.
Kalyan Chandra Sarkar versus Rajesh Ranjan, alias Papua Yadav, AIR 2005,
Yes.
SC 921.
Year 2005 SC 921 paragraph. Which para do you rely upon? Which paragraphs? You see, I won't be able to read the entire judgment. I'll read the entire judgment if I feel convinced that the relevant para is of some use.
Yes,
Counsel,
Your Lordship. I plead ignorance in this matter, Your Lordship.
Counsel, can you please tell us the facts of Papua Yadav's case? Because I think that's a 32-year-old kidnapping matter. Yeah, how are you trying to, bring this in tandem with the facts of your case?
Your Lordship, what I want to highlight is that since it's a subsequent bail application, so
I
it must
understand,
receive
Counsel, but what happened in that case, if my memory serves me right, is that over a period of 32 years, Papua Yadav made successive bail applications, and that was taken into consideration by the Honorable Supreme Court in 2005. In view of the fact that for the last 32 years there have been successive bail applications being made, that was a ground on which the Honorable Supreme Court said. In your case, it's what, barely 200 days, Counsel. How do you reconcile these two?
And isn't this a question of bail before us for the first time, before the apex court? Isn't it for the first time? How is it a successive application? Haven't you approached the Supreme Court for the first time?
Yes, Your Lordship, actually, before this.
So when is it a successive bails are bails when you apply before the same court again and again, and the same court keeps rejecting, and then there's a law that if there are subsequent developments, facts change, circumstances change, time goes by, chat sheets file, you have new grounds to apply for bail and you keep applying, and subsequent bail applications may be maintainable. But here you're impugning a high court order. You're before us for the first time. How is this subsequent application of any relevance? This point of successive bail applications of any relevance?
May I be permitted to answer this, Your Lordship?
Yes, please do.
Your Lordships, the charge sheet was filed on final charge sheet was filed on 30th April, and the bail prayer before the High Court was made on 5th July. So in between, about 2 months have passed. So in between these 2 months, the person was in judicial custody. So by common knowledge, we know that in between this time, the trial court is always approached for bail, and successively after every few days, bail applications are made. So by that case, we want to say that successively bail applications were rejected by the lower court.
Aren't you reading too much into the law, Counsel?
Apologies if you have made any mistake, Your Lordship.
I mean, of course, you get 90 days to approach the Supreme Court by way of an SLP. What was the date on which the Honorable High Court rejects your order?
It was on 5th July.
5th July.
It was approached on 5th July. When it was disposed of, it is not mentioned.
All right, let's assume that 5th July it happens. 6th July, the Honorable High Court issues notice. Say, with as expeditious as it is, within 2 weeks, the state files its counter. The matter is immediately taken up for hearing. By July end, the order is confirmed, rejecting your bail. August, September, October, the matter is taken up before the Supreme Court. Notice is issued to the other side. We convene a bench and then we direct the matter to be listed and heard finally. Of course, Counsel, you have to. I think the judicial system is doing an exceptional job in your case.
This is a complete miscarriage of justice that the common man is suffering. That's why we are getting this, the Lordships.
All right.
It's a common minority man suffering in a draconian anti-conversion law.
That year 2005 Supreme Court. Can you just tell me which paragraph are you relying on?
Your Lordships, currently which paragraph is not at present is available with us at the moment.
That's okay. I'll look it up. When I take my files home and prepare for the next year, I'll look it up. Just tell me the paragraph number. Is there a paragraph?
Your voice is breaking, Your Lordship.
I'm saying, is there any specific paragraph that you rely upon, or are you just in an abstract manner relying upon a judgment?
It was not exactly based on a paragraph. It was the observation that we referred from the court.
Very well, but that observation was in which paragraph of the judgment?
That exact paragraph number is currently not with us at the moment. Your Lordships, we plead ignorance on that matter. We had submitted our memorials a long time back.
Okay, I have noted your ignorance. I just have one short question, one last question. You see, it's okay. I think I'll put this after I have the arrest. It's okay. Thank you.
Much obliged, Your Lordships.
my brother judges, I suppose if they're done with, could we move on to the other side?
Yes.
Your Lordship, could I proceed with the? Could I proceed?
With your prayer, yes, please. Yes, please do it within 30
Could I be granted a minute? Yes, Your Lordship.
Just tell us, madam. Just tell us what you want from us. Just tell us what you want from us, and then we'll think over it. Just tell us what you're seeking. What do you want from us today? Today we're going to pass an order. What do you want? What relief do you want from us? Tell us.
Yes, Your Lordship. Your Lordship, as is evident from the facts of the case, that the accused has been languishing in jail for months without trial and without framing of charges. So, we would appeal for him to be released on bail under any stringent terms and conditions as the court deems fit. And with this, I would like to proceed with the prayer. In the light of the facts stated, arguments advanced, and authorities cited, the counsels for the petitioner or appellant most humbly request this honorable court to adjudge and declare that the present writ petition is allowed and the Georgetown Freedom of Religion Act 2021 is ultra vires of the Constitution of Georgetown on account of its vices of arbitrariness and gross violation of the various fundamental rights. And Rana alias Mana is entitled to be released on bail under any stringent terms and conditions deemed fit by this honorable court. The counsels for the petitioner would also like to request this court to pass any such order which it deems fit in the interest of justice, equity, and good conscience. Much obliged, Your Lordships.
Okay, thank you. Thank you, madam.
Can we have the respondents, please?
Permission to speak, Your Lordships?
Yes, madam, I have a query. You see, now we apply to the facts. My request would be not to reiterate facts unless my brother judges want some clarification on facts. Secondly, I see there seems to be a prima facie case having been made out. That there may be something worth considering insofar as the wires of the provision is concerned. So I think today being the first day, I may want to stay the provision. I may want to stay the statutory provision or stay the statute, so to say. So could you just address me on that? Tell me law, can I stay a statute? And what is the threshold that I need to consider before I stay what the parliament has decided?
If I may clarify, Your Lordship, you want to, the Lordship wants me to clarify whether the Parliament has the legislative competence to
assist me, please. I want to know if I can stay the operation of the statute, which is in question today, pending final adjudication. If I can do that, and whether, if at all I can do that, in what circumstances can I do that? And if there are any precedents on this, just please assist me with that, if possible.
Your Lordship, the counsel for the respondents would like to state that state arguments in favor of the fact that the act is completely constitutional. It is in par with the constitutional provisions and it is not ultra virus. I want to proceed explaining why this act is ultra virus. Firstly, the counsel for the petitioner has taken up the call that the
is it? Are you saying it's ultra virus?
No, it's completely intra-virus. My apologies, Your Lordship. It's intra-virus. The counsel for the petitioner has taken up the plea that the Union Parliament does not have the competency to pass the impugned legislation. In this regard, I must point out that regard must be had to what the main subject of the act is. The main subject of the act is to provide legal religious liberty to an individual. It is to protect the freedom of an individual. It relates to the religion as such in pith and substance. Yes, it can be said that there are reasonable restrictions imposed upon the religious liberty of an individual under Section 10 of the Impugned Act, by which it states that 60 days advance notice has to be given before conversion can be done. But that is a reasonable restrictions.
Counsel, please, I'm so sorry to break your flow, Counsel, but please help us understand, how does marriage per se become a reasonable restriction? Because we understand that coercion, undue influence, fraud, etc., may be legitimate grounds for the state to interfere and call that conversion a conversion which is bad in law. We understand. But the operational part of section 3 has something else to say. It puts marriage as a subcategory. So can you please satisfy us? Because I think all my brother judges and I are of the view that that is a singularly sufficient ground to, at least for now, stay the entire operation of the act.
Yes, Your Lordship. What I want to point out is that marriage is sometimes used by men. Particularly, I'm going to use the term men because women are a vulnerable class who can be easily influenced. So men sometimes use marriage as a tool to misguide or to cause a fraud upon women, to and make them enter into a matrimonial relationship and then pressurize them to convert their marriage.
Is the statute gender neutral, counsel, or does it only charge men?
Yes, Your Lordship, it's gender neutral. But if we look at the current scenario, or if we look in general, the weak and the vulnerable class, and there is a need specifically to protect women, because in case of, if we see that in cases of marriage, it is women who are in general persuaded by men to enter into marriage, and then they are forced to convert.
Are women incapable of autonomy, or are women incapable of asking men to marry them?
Yes, Your Lordship.
What line of argument is this, counsel?
Yes, Your Lordship, that can also be the case. Then the situation will equally apply for men also. So if I may direct the attention of the judges to the moot problem. In the moot problem, it is stated that the religious composition of the country, Georgetown country, it's 80% Vedumism and 20% atheism. So it can very well be stated that those minority religion, sometimes they might feel the fear of religious persecution. The religious persecution thing might go on in their mind, as a result of which they might try to enlarge their population to be
Counsel, again, does the law make any segregation on the basis of religious minority or majority, or does it penalize conversion per se?
It penalizes conversion per se.
Counsel, again, we fail to appreciate the argument then, because first you try to make a distinction between men and women, then you are trying to make a distinction between religious majoritism and minority. Counsel, your task as the counsel for state is to defend the virus of the statutory provision. We have asked you a pinpointed question, which is conversion. How can you equate marriage and how can you penalize marriage if it leads to conversion? A marriage simpliciter, because that's the word which is used in the provision.
The act only penalizes those marriages which are used as a tool to make the spouse convert their religion. If after an interfaith couple has contracted their marriages and one of them wants to change their religion and enter into a different religion, to follow the religion of their spouses, they are free to do so. If voluntarily they want, they have the right under Article 25, and they can follow the procedure as provided under Section 10 of the Act, and they can change their religion. What this Act specifically provides for is to declare those marriages void, which under which the spouses or a particular spouse is forced to change their religion just by using marriage as a tool.
Counsel, the word force, undue influence, coercion does not feature. Section 3 creates marriage as a category independent for the purpose of conversion, and that is penalized. That's our problem. Can you please read Section 3 again for our benefit?
Yes, Your Lordship. Section 3 states that no person shall convert or attempt to convert, either directly or otherwise, any other person by use of misrepresentation, allurement, use of threat or force, undue influence, coercion, or marriage, or by other fraudulent means.
So you are putting marriage in the same category as undue influence, coercion, fraud.
This the intention of the legislature in including marriage is that when marriages are used as a means by the people for conversion, it is used as a tool for the people to convert.
Counsel, this is a penal statute.
Yes, Your Lordship.
It has to be construed strictly.
Yes, Your Lordship.
Right. And what does it say? Marriage is a standalone independent ground. You are trying to qualify that marriage, when done on account of coercion, undue influence, that may not mean. I think it's conferring unfettered discretionary power on the executive to decide which marriage will fall under compulsion and which marriage would be a free marriage. You will get a free pass, all of you.
Your Lordship, here
In
marriage.
addition to what my learned brother said, you're also saying that the accused needs to then prove that he is not guilty. So it's in that sense, it's an out and out blatant power really in the hands of the state.
Your Lordship, marriage.
I think this seems arbitrary, and being arbitrary, it's hit by Article 14. That's my prima facie view. You please satisfy me on that.
Your Lordship, when the language of Section 3 states that conversion or for the purpose of marriage, the particular language of the statute is that conversion for the purpose of marriage. Now, the Supreme Court has on various occasions held that conversion for the sole purpose of marriage is void. For example, in Sarla Mudgal's case, the Supreme Court stated that if a man undergoes a conversion just to contract a second marriage without nullifying his first marriage, that conversion as well as that marriage will be void. So if a person in this under Section 3, if a person contracts a marriage or if a person undergoes a marriage with a malified intention of converting to take some benefits, to get some benefits, because each religion has a separate family law of its own, from which it derives several benefits. So if they have a malified intention in entering into marriage, that should be strictly prohibited.
That's all right, counsel, but you already have so many different laws. I mean, if somebody has contracted by deceit, that's a standalone ground for annulment. Why have this penal provision? Why do you want to penalize the conduct? I mean, we have taken a view in Joseph Shine and so many other cases that essentially offenses relating to marriages, polygamy, etc., adulterous conduct is no longer, we have decriminalized it. Why do you think that this bench, in utmost fairness, would allow this law to sustain?
Your Lordship, as I have already stated, that when this act is enacted with the intention of restricting forcible conversion. So on the ground of marriage, if forcible conversion do take place, that is what the act is trying to prohibit.
Fair point. Is there a sunset clause to it? Is there a particular framework that within X number of days, if you decide to convert, then what you say may hold some water? What do you think, according to you, is a reasonable period within which a person, it could be demonstrated that a person immediately converted as soon as the marriage was contracted, so as to give some credence? Is there some empirical study? Is there anything on record that you can show to us to justify that this law was a necessity?
Can your Lordship please repeat the question?
Well, the question is that, is there a sunset clause to this? Which is to say that within X number of days, you are saying that if the marriage is contracted purely for the purpose of conversion, therefore it would be penalized. Can you earmark as to is there anything in the statute which says that, within X number of days, immediately upon marriage, if you do convert, then this provision will kick in and then you would be held liable? Or is there any intention of the legislature? You have a rule-making power to introduce that period of time in your rules.
No, Your Lordship, it is not included in the legislation as to what is that reasonable period of time, but it is indeed necessary for
so
determining.
Disgruntled couples after 2 years can suddenly walk up one day to the police station and say that, look here, please, he got married immediately after, he converted, he married to me for the purpose of conversion. Therefore, you proceed to frame somebody and imprison them for 10 years. I think that's a bit of a stretch, counsel.
Yes, Your Lordship. I think in that case, the reasonable time should be taken into consideration. What is that reasonable time? That has to be decided by the court, whether...
Counsel, we can't legislate. We can't fill your lacunae. It is for, therefore, the query pointed out to you that A, there is a power to make rules. Are you intending to make certain rules so that until those rules are framed, we'll stay the operation of the act? Will you be...
if we want to stay the operation of the act, you want to cite some law to say that there is a presumption of constitutionality and therefore stay ought to be avoided. Are you relying upon any judgment in this regard?
No, Your Lordship.
Okay. Are you the Attorney General, madam?
Yes, Your Lordship.
Representing the state. And who will address us next? The Solicitor General?
Yeah.
Yes, could we?
Yes.
We'd like to hear him now. I suppose we'd like to hear the Solicitor General address us.
Okay, Your Lordship.
Permission to approach the bench, Ships.
Yes, Mr. Mehta, please proceed.
To begin with, Your Lordship, it is a huge thing to be compared with him, but I'll still go ahead with the submissions. Good afternoon, Your Lordships. I'm Speaker 2. I'll be representing the respondents for the issue 2, which is whether Rana alias Mana, the appellant, can be granted bail. At the outset, Your Lordships, we would like to submit that there is no point of dispute in the allegations made in the FIR. So had there been any dispute, the appellant could have gone for other legal remedies or recourses like quashing the FIR under section 482 of CRPC at the very nascent stage. But that was not done. So since that course was not taken, we are saying that the allegations, they hold true. Now, when the court is
Counsel, are you saying that a person must be made to suffer the rigors of the trial when he has something called an unimpeachable evidence? If the person has demonstrated that the parties were known to each other 4 months prior to them contracting the wedding, he has a good ground to contest that, of course, it was consensual, and of course, there's a sour flavor which has been added to it. And in Annesh Kumar, we have already held that matrimonial disputes of any nature which carry with it an imprisonment term, we would be very, very hesitant in not allowing, in not enlarging a person on bail in such a scenario. Tell me something, counsel, did you comply with 41A notice? Did you send them a section 41A notice? Because CRPC is applicable under the statute.
I'm afraid, Your Lordship, the facts are silent on that
You strictly
issue.
went ahead and arrested the person. Am I right?
The arrest was done in compliance with this case, the statute. I'm sorry, the statute of Georgetown Freedom of Religion Act, which says this is a cognizable
Counsel,
offense.
we had given express directions to all the DGPs of state in Annesh Kumar, where we had unequivocally stated that you have to comply with 41A and it is not a mere procedural formality.
Right, but Your Lordship, the facts are silent on that, so I cannot really comment on it.
Counsel,
but
it doesn't have to be from the facts. I mean,
actually,
is there a compliance, yes or no?
I mean, Your Lordship, if I say that yes, we have, then how can I support that statement?
What is the necessity to arrest a person? Is this a heinous offense?
Are you conceding? Are you conceding that 41A has not been complied with? Because if 41A has not been complied with, we let him free. This wife thing can be decided, but you can't violate 41A and then have somebody languishing in jail.
Friend, well, Lordship, I cannot state anything on that, because
in fact, we'll hold the investigating officer for contempt if he's not followed 41A. In a matrimonial dispute, you just go and pick somebody up.
Your Lordship, this expeditious thing was done.
How is your menace to society? Tell me, if he is on bail, how will how will anybody be worse off if he's on bail? Who will suffer?
If he is released on bail, there are two things that we are anxious about. One first apprehension is, since the trial has not commenced, as we can see from the fact, he can easily and the burden of proof is on him again. So he cannot. It is possible for him to go and tamper with the witness or even flee, because the severity of punishment is such that
all right,
he can,
we'll pass a direction to the effect that he will not reside in the same jurisdiction. He will report to a police station in a separate jurisdiction. All right, that concern is legitimate. Now, will you concede if we were to grant bail on such conditions?
No, Your Lordship, because again, if he goes out,
we'll also impound his passport. Let me clarify further. We'll also impound his passport, and he'll be reporting to the police station between 1 p.m. to 2 p.m. every Tuesday, Thursday, and Saturday.
Right. So even in that case,
Mr. Mehta, we have given you more than what you have asked for.
I am afraid. Okay, but Your Lordship, even in that case, we cannot guarantee that he cannot appoint someone else, or someone else
Counsel, can we? There's a specific provision in the CRPC for cancellation of bail. If you feel that he has done anything, then you can always apply for cancellation. If you think that our conditions are violated, that gives you a standalone cause of action. Why do you, merely on an apprehension that he will commit something, he will do it through some proxy, is no ground to keep a person languishing in prison?
Your Lordship, but then if he is released on bail, like, we cannot for sure say that how long this case will go on. But if it does,
you are conceding that the trial is likely to take an inordinate period of time, and therefore all the more you are destroying your case.
No, because the onus of proof is on the appellant, right, the accused. So so he has to prove his case. And what if that goes on for a while, and he will be out? He will be out at large.
But so, the prosecution will first lead evidence, correct? Let's say you examine 200 witnesses in support of your case. The gentleman would be languishing in prison for 7 years, 8 years straight until the prosecution evidence is over. What kind of strategy is that, counsel?
Yes, Lordship, but then since this case, yes.
I have an additional question. Are you aware of the provisions for default bail?
I'm afraid no, Your Lordship.
For how long have you kept the accused behind bars?
Your Lordship, he was arrested on 30th April, if I'm not wrong.
And anyway, given that the High Court rejected the order on 5th of July, and you're thereafter really in that sense, in fact, by the way, is it 30th April under the facts? Before I go further, was he arrested on 30th April, or was the charge sheet filed on 30th of
April? I'm sorry, Your Lordship, it was a little mistake on my side.
When was he arrested? It was 31st March. I'm sorry, Your Lordship. It was 31st March. He was arrested, and the charge sheet was filed on 30th April. Yes. Right. And the offense, I believe that the IPC offenses which have been alleged are all bailable. That's right.
The IPC, yes, they are. Yes.
Right. So, insofar as only the non-bailable provisions are of the Freedom of Religion Act, correct?
Yes. Yes. Yes.
Correct. And what is the punishment, maximum punishment that has been provided?
It's of 10 years.
Correct.
Maximum of 10 years. Yes.
Therefore, if 90 days period is over, the accused will become entitled to default bail. Now, given that provision, how do you justify him still continuing in jail despite the default bail provision say, and despite the fact that the charge sheet has been filed? Are you saying that, and what is the emphasis of the charge sheet? The fact that the charge sheet is filed, what is the nature of the document? The charge sheet is what kind of a document is it?
The charge sheet is just the conclusion of the investigation, but that
correct. So therefore, the investigation is over. Otherwise, you wouldn't have filed charge sheet. Therefore, and the 90-day period is over, by virtue of which you would be entitled to default bail. Then, what is the reason to keep him continuously behind bars?
Your Lordship, one bail application was also filed in the High Court, and the High Court had rejected the bail also. So now
No,
that
but
it
why
is
should we not grant? High Court may have rejected, but given these two glaring facts, why should we not approve the bail and grant the bail?
Your Lordship, because it is an exceptional case here. I mean, we know as a rule that the bail is rule and jail is exception. But we are saying, we are submitting that this is an exceptional case because this situation is that the moral conscience of this nation is at stake. I mean, we are trying to establish that this offense of forcefully converting someone through fraud or misrepresentation, whatever, that is wrong, and that actually affects the society.
But let the
So,
trial decide that. No, you are prejudging him even before the trial has commenced in that sense. The
so,
charges are yet
that-
not framed. How are you deciding on morality without the trial being conducted? You're deciding him guilty even before the trial takes place.
So that the appellant has a right to do. So if he does go to the trial court, then that is another matter. But right now we are saying that bail should not be granted because this the punishment is quite severe and the offense is quite serious. So we are saying that if he is released on bail, then it gives a different, it gives the example that is said that might cause other people to
But
follow
it
his
is
path.
his allegation that the conversion, there was no forceful conversion. And in fact, I believe your moot problem also says that the wife converted out of her own free will.
Right, Your Lordship, that was a statement given to the police, and that cannot be really admissible in
So
court.
therefore, the trial will have to be conducted, no, in order to verify whether that's
Then-
correct or not.
then-
No, and
then
also,
in this case-
also that statement given to police may not assist the prosecution. It will most certainly assist the accused. If the accused has said that this was on account of consensual thing, then do you think that the superior courts are precluded from even examining a 161 statement?
No, Your Lordship, but then since
Counsel, what is the law on 161 statement then? Can we not at this preliminary stage, let's say even after charge sheet is filed, not examine the contents of 161 statement to if it supports the defense?
May I allowed to look into the provision if it's?
You don't know what 161 CRPC is, counsel?
I'm afraid I don't remember at this moment, Your Lordship.
Very well, counsel. Mr. Mehta.
I am not.
One additional question, counsel. That
Yes.
I believe that the statute says that the burden of proof lies on the accused. How do you read that in comparison to the provisions of the Evidence Act, which say that the burden of proof will lie on the person alleging it? Would it not therefore be violative of the Evidence Act?
Your Lordship, counsel.
Would it not in ordinary circumstances, the burden to prove a particular fact would lie on the person who's alleging it? So if it is your case that the conversion happened and therefore there's a violation, etc., how do you expect, how do you justify the wires of Section 10? Because that is effectively completely against the one Evidence Act, of course, and secondly, of course, constitutional provisions also in terms of Article 20, Article 21, etc. How is it really in that sense fair to the accused?
Your Lordship, in this case, since the provision which says that what shall constitute as an offense, the accused will have to prove that he does not have a malified intention, because the complainant will. I mean, how can the complainant say that he or she was not subjected through coercion or under influence? Because that's what he's complaining, that I feel that I have been subjected to these things, and yes, for coercion or under influence or misrepresentation. But then in that case, the accused can only prove that he did not have any malified intention and his intentions were only bona fide. So that is why
But
the onus has been.
where do you get under Section 12 of the Act that where is the word malified intent used? Where do you get that from Section 12 of the Act?
Your Lordship, if the accused has to prove that he is not, that the allegations against him is false, then that is, the the whole the intention of coercion or undue influence, that is malified, the whole intention. So that if he has to prove that he is not the accused and the allegations are false, then he'll have to prove that these allegations, that intention that is being questioned, that was not malified. I mean, that is malified, but his intentions were not.
Maybe I'm not reading it correct. Can you point where in the statute in section 12 does it use the word malified?
It does not, Your Lordship. I'm stating that as my reply. I mean, answer to your question.
No, so therefore, sorry, I'm not clear. So therefore, where do you say malified intent? It says the burden of proof as to whether a conversion was affected through misrepresentation, allurement, etc. is for the purpose of carrying out, lies on the accused for the purpose of carrying out conversion. Where do you get malified intent? You just need to prove, the only burden would be to say whether there's misrepresentation or in that sense allurement or whatever the other provisions. But where do you get malified intent?
Your Lordship, these acts of misrepresentation, allurement, or use of force, that itself brings in the malified intention. If I am to coerce someone to do something, I have a malified intention, which is why I'm coercing that person to do it.
Counsel, you are trying. Counsel, there's something called mens rea, right? Are you saying that contracting a marriage would clothe you with mens rea?
I mean, that's what the this act is for. If I'm using marriage to persuade someone to convert their religion, that would
Counsel, but this case is slightly different, right? This is not a case where he has persuaded the wife to convert. He has himself not disclosed what his religion was. This is not a case of convert.
That he's suppressing some facts. I mean, why would he suppress?
That gives you a standalone cause of action under a different law. But to say that this would somehow fall within the category of mens rea, I think that's.
Your Lordship, if someone is suppressing some fact, that would amount to misrepresentation. Because if the marriage was solemnized under Verum religion, Verum traditions, right? So if he suppressed those facts that he is an atheist actually, and after marriage he came to know, and then he is threatening her to convert your religion to atheism.
Counsel, where do you get this that he is threatening her to convert to the religion?
It is in the facts, Your Lordship. It is in the facts.
Please show us which paragraph.
And does the fact also speak about there has been a suppression of such statement that
part we agree with you, but the fact that when it was disclosed that he belongs to a different religion, there was a threat to convert.
Yes, Your Lordship. If Your Lordships could come to paragraph 4 of the facts,
right?
In the third last line, after learning his true religious identity, she received constant pressure for getting converted into atheism. She received repeated threats from Mana, was locked up in a room and not allowed to meet her family members.
And Counsel, then the ideal provision therefore would be 342.
Yes, Your Lordship, but then this is like what we're trying to submit is that this offense is more serious than the other. I'm sorry, I'll just rephrase myself. This is a very serious offense. So, which is why this act has come into force, so that this can
Counsel,
be
are you telling us that confining a person against their will for X number of days, thereby taking away their liberty, versus an inducement, let's say a marriage which becomes a precursor to conversion, you put this as a lighter offense as against the former one?
No, Your Lordship, there is no lighter offense, but then since
you just said that's a more severe offense than this.
Actually, that's what I would say. I will rephrase myself. That's what I would say. Because marriage is a sacramental institution in Georgetown. So using marriage to convert someone to another religion, that would be quite serious offense. I mean, wrongful restraint is also serious. I won't say it's less serious something, but then it is also serious. But then conversion, this converting someone, I mean, this intention is bad. It's actually worse. I can use.
Counsel, what is the maximum period of imprisonment under 342?
Under 342, it's 1 year. No. 1 year, Your Lordship. If I'm not very wrong.
Are you sure?
Can I be allowed to consult with my researcher? I mean, I know it's
Counsel.
either 1 year or 2 years. I mean, I'm just confused between the three sections.
Up to 1 year.
Up to 1 year, yes.
Up
Thank
to
you,
1
Lordship.
year.
Much obliged, Lordship. To 1 year, yes.
And counsel, in essence, the allegations surrounding threat, the allegations surrounding not allowing somebody to leave carries a maximum imprisonment of 1 year. Then by that logic, we must enlarge him on bail, don't you think?
No, I mean, Your Lordship, those three sections are penal sections. Those are bailable. We are not going into that. We are opposing
Counsel,
the bail on the
155 CRPC kicks in that wherever there's a non-bailable provision and then bailable provisions also partake the character of a non-bailable provision and
Yes,
must be tried as such. So don't say that we are not going into this. You have to, as a counsel for the state, it's your responsibility to press every provision into service. Unless you feel that IPC provisions need not be added. In which case, counsel, will you assist us in?
No, Your Lordship, that is not what we are. That's not what we would say.
Then we have powers under 136, 142 to even quash those provisions if you feel they are irrelevant.
Which provisions, if you can please?
If
which
you feel that
provisions
42, etc., were added and they were added just for the heck of it, and the real intent was to prosecute the person under the religious conversion law alone, then we will set aside those provisions.
Pardon me if I'm not able to understand if that is done, what would be the consequence? But I would say that I would obviously come back to this one provision, the non-bailable provision that we have. It is made non-bailable, and the reason is quite serious. I mean, the state obviously is trying to establish that this is a serious matter and it will be dealt with quite strictly. So I would say that.
Counsel, what empirical evidence do you have to suggest that this is some sort of a problem which has gone out of proportion that necessitated bringing this law? Is there anything which shows that religious conversion was on a rise and you wanted to quell this down? Since so many laws are in pari materia with India, I'm sure the circumstances too would justify bringing this enactment. Was that exercise even carried out, counsel?
The laws may be pari materia with India, but then Georgetown and India are two different nations, of course, and obviously the.
Counsel, you are aware of our decision in Maratha reservation matter, where we say that if the parliament or the legislature wants to bring out a law, there has to be some research, some empirical evidence. You can't do this hit and trial method. You first bring a law, and then when somebody challenges it, and then we question you, you then come out and say, sorry, there is no research to support why we wanted to bring this law.
If Your Lordship could give me just 1 minute to go through the facts, I think I have something. If Your Lordship could come to point para 2 of the facts, it is said that there have been a few scattered incidents of communal disharmony, and after GDP came into power, they wanted to restore. They wanted to prohibit the forcible conversion of marriage by getting a person married, like yes. So it is just to make sure that this communal disharmony does not rise into something which would cause such problems. So this is just a prohibitionary act. Just in case that happens, there is already an act in place so that can be taken care of.
You also have preventive detention laws. If the ultimate aim is to prevent these offenses from happening, then you have NSA, you have so many other provisions, Defense of India rules, etc., etc. You can always press them into service. The Preventive Detention Act 1987 is there to save you. I mean, why bring this law again?
Your Lordship, this would just act as a how can I say? Your Lordship could give me a minute. This act
Besides,
would just. Your Lordship?
yes, this act would please.
Yeah, this act would I mean the scope of this act would be a bit more narrower than the other the statutes that you mentioned, because it is just to make sure that this communal disharmony does not affect the religion, the religious this
Council, we understand that, but our hands are tied. You see, in Puttaswamy, 11 judges bench of this honorable court has already held that a right to choose their partner trumps every other provision. So it's a concomitant right inherent to 14, 19, 21, the golden triangle that your predecessor council alluded to. So even if we were to agree with you, this provision at least falls foul of that very cherished right to choose a life partner, whatever may be the circumstances.
Yes, Your Lordship, but then this case is currently in place, right? So right now the situations are such in Georgetown. The situations are such that this warrants such an order to be passed and this act to be upheld. I mean,
Council,
see,
are you asking us to give you a relief which is completely against a decision of a superior bench strength court? We are bound by an 11-judge bench decision in Puttaswamy. We can't give you the kind of relief you are asking us to, because that would tantamount to us transgressing the domain which has already been held to be good law.
Your Lordship, like in our prayer only, we'll say that any order that the court would deem fit, but then I mean there is always this
Council,
I don't know if I should be saying this.
Do you agree that this law impedes the right of choice of an individual to choose their partner?
No, Your Lordship. No, Your Lordship. Because if you if we can just 1 second, if we can go through this act, there is this provision. Yes, this section 7 that says that every petition for declaring a marriage null and void, the court have jurisdiction of a family court within local limits wherein the marriage was solemnized. So the marriage can be solemnized if a notice is given to the district magistrate for 60 days. I mean, my friend co-counselor, she was saying that there's no reasonable limit, but then the 60 days notice can be given to the district magistrate that I want to convert my religion. Right. So, I mean, if that is there and there it says that the jurisdiction is there when the marriage was solemnized. So basically, the petition can be filed after the marriage was solemnized and the district magistrate would look into it. I mean, sorry, the Court of Sessions can look into it. But then it is also saying that the marriage was solemnized. So it is taking into account something that has already been solemnized. So if I get married to someone who is from a different religion, yeah, and I have converted or converted, whatever it might be. If I want, I cannot go for such null and void petition. In which case, this act will continue as it is. I mean, sorry, the marriage will continue as it is, and it will not be in contravention to this. It is only when one party is causing this petition that no, it was wrong, I have been coerced or unduly influenced. That is when this act comes into play.
All right, Council, please proceed to your prayers. Is there something else that you would want to argue?
Just one thing, Your Lordship, just one thing that's been playing on my mind constantly.
And you assume that should also play in our minds by extension.
I mean, it should definitely, like Your Lordship, way more.
Please proceed to your prayers.
Okay, Your Lordship. In the in the lights of the facts stated, arguments advanced and authorities cited, that we counsels for respondents most humbly request the court to uphold the constitutional validity of the Georgetown Freedom of Religion Act, and second, pass an order rejecting the bail of the appellant. The counsels for the appellant would also like to request for the court to pass
an order rejecting the bail. Or do you want us to? why have you not asked for the special leave petition to be dismissed or the leave to not be granted in this matter? Counsel, when you're moving under Article 136, it's the leave to appeal which is being sought from the Honorable Supreme Court. So
Much
should your
obliged,
prayer
Lordship.
not contain a clause to the effect that leave may not be granted?
I stand corrected,
The
Your
SLP
Lordship.
be
I stand
dismissed?
corrected.
Yeah,
I
instead
stand
of asking for
corrected, Your
rejection
Lordship.
of bail, it's our
Yes,
choice. We may, while
Mhm.
admitting SLP, also reject bail. We may, while refusing to admit the SLP, also let the bail stand.
I stand corrected, Your
Are
Lordship.
you
I will so
curtailing
do.
our powers, Counsel? Do you understand the width and scope of Article 136?
I stand corrected, Your Lordship. I made a
Better
mistake.
worded prayer would have been better.
Yes, Your Lordship. So can I change it? Because in our memorial, we have already mentioned that to pass an order
No, Counsel,
rejecting
you are
the
bound
bill.
by your pleadings. That's another salutary principle in CPC. You might want to look at it. It's always good to read CPC.
Absolutely, Your Lordship. I'm much obliged.
Then,
And
Counsel,
the
another
court,
follow-up query. Are we bound by
yes.
CPC? As the Supreme Court of India, are we bound by CPC? Or CRPC for that matter?
CRPC, yes, because this is a criminal matter. So CRPC, yes.
No, Counsel,
I'm
as
not
rules
sure
of
about
procedure go of the Honorable
Mm.
Supreme Court of India, are we bound by the terms of CPC or CRPC? Since you have approached the Supreme Court and Mr. Mehta is a practicing counsel for so many years, so you would want to enlighten us.
As far as my knowledge goes, I'm not Mr. Mehta, of course. As far as my knowledge goes, I mean, since this is a criminal case, then I mean, yes, since it's a criminal case, then CRPC would, I mean, the court can
Very
use
well,
the
Counsel.
provisions.
Thank you so much. Is there a
Thank you.
rebuttal
Much
or a
obliged.
surrebuttal which has to happen?
A
The
small
organizer?
rebuttal is allowed by the committee. A rebuttal is not. So permission for a small, very small rebuttal to save the time.
2 minutes. 2 minutes.
We'll take less than that also if you to sum it up if necessary. We'll just cite one point for bail and 1 point against the constitutionality. So coming to the bail issue first, one argument for that is, your lordships, we are all aware of the present COVID-19 pandemic situations and the crowding of the prison. So under these situations, it is humbly prayed that he should be released, considering that he has to prepare for his trial and whatnot.
Counsel, are you aware of our order dated 15th October 2021?
And we plead ignorance in this matter, your lordship.
Then Counsel, you would not have raised this submission. Next point.
Next point is that regarding the coming to the constitutionality of the matter, one small analogy is given that we are not in support of forcible conversions. Nobody is, because it is illegal. Forcible conversion should not happen any day. But in that analogy, if we compare the state of Georgetown to a patient suffering from the disease of forcible conversions, what this act is trying to do is trying to cure this disease and has made a medicine that is so bad and is so full of side effects that it violates the fundamental rights of the citizens of Georgetown. So under the watch of this honorable bench, this should not happen, your lordships. And he should be released in bail as the earliest without any prejudice to his individual dignity and other fundamental rights. That's all, your lordships. Much obliged.
Thank you. Thank you so much, Counsel. The organizers would be redirected. Are we supposed to send us our individual graded list and mail it to you, or would you like us to confer first amongst ourselves and then send the cumulative scores?
So your lordship, if you wish to, then we can move you to a private room where you can discuss with your brother justices and send us a cumulative score sheet.
All right. And will there be a feedback after that?
Yes, sir. Like
Yes.
it's your discretion, sir.
No, I think you would want to avail that because there's a lot which has to be said.
Sure.
With the permission of my learned brothers, would you prefer going to a separate room to deliberate?
I have actually given scores, so I would be okay with just the scores itself.
All right, so we'll give the scores then. We'll mail.
We'll just email the
Dash,
scores.
what do you think?
Yeah, we'll just email the scores. That would be fine.
Right. So I think then we can move ahead with the feedback session.
Yeah, would you want to do the feedback right away? I'm okay with that.
Same. Yeah.
Okay. So should I go first?
Please.
Okay, I think it was quite hotly contested, and I think all of you did fairly well. Just a couple of observations. Sometimes, I mean, I think one of the memories that come back to judging moot court competitions. We remember our time when we would be petrified the night before, and you're all over the country and you're doing these tough moots, etc. One is, I think, when you're reading a problem, it's important to see when you say pari material laws means all laws apply. So you all will have to be slightly more broad-based, because even in practice, when you start working, you'll realize that it's not, you can't just have a very, specific picture of what's really on your hand, because like the kind of questions you get come from code, it can be really anything under the sun, and it has to be quick thinking on the feet. So if you're looking at pari material, you're bound to know certain basic concepts, and obviously I assume most of you are final year law students, so you'll also be fairly well versed with your, at least would have studied some part of your course in terms of your procedural law. So that's really my only takeaway, and I think don't really get unfazed, with all these questions that come, because honestly courts are far worse. But at the same time, each day is a learning, and you really enjoy doing it. So keep the spirits up, and I think all of you did fairly well. All the best. That's really it from my end.
Okay, can I move ahead? Yeah. So I would not speak anything on this approach that you have made to present your arguments, but I would be more critical on the submissions that you have made. Okay. So this is a clubbing of two matters together. So you must be knowing about what are the powers that the Supreme Court has to entertain the matter. That is number one, when you are submitting through your memorial. Number two, you must know who you are, because in one of the memorandum that has been submitted to us, one is speaking about the petitioner and one is speaking about an appellant. Okay, so while using these words, you must be very careful of what the situation of the case is and what should be the right nomenclature that you should be using. Plus, the one more thing, that there is a lot of glossary that you have given as a matter of supplementary documents that you have relied on. So when the judges are asking you about why have you relied on these judgments, you should be aware at least of the facts about the quorum, about the ratio, and why is it applicable to this case, because you are requesting or you're expecting the court to be really dependent on that case to decide such matter. And lastly, when you are making such arguments in multifold or in manifold, you should be knowing that whether it is actually leading to the prayer you are actually making. Okay, so your arguments must be complementing and supplementing to the prayer. It should not be having a disconnect. Just like if you are actually you're asking for a prayer, then whether you have made that argument through your submissions or not, whether it has been accepted or not. And you also need to get that thing that if it has not been bought by the judges throughout your submissions, how best can you put forth, how best can you channelize your submissions so that it can be actually be appreciated by the court. These are the few points that you need to have a look. And lastly, when you're making the submissions, most of you have not referred, generally in a moot court practice, not in a courtroom practice, but in a moot court practice, you try to relate the fact sheet comprehensively with your arguments, with your supporting documents. These are three things we generally look forward to. So somewhat you need to work more on this thing. Okay, these are the few points from my end.
I think there's another learned judge with us, but
I think he has got disconnected.
I think, okay. All right, so I'll make it as brief as possible because I've already said whatever I had to say during my questionings. Number one, please be organized. Your organizational structure of your arguments is very, very important, considering that you have the benefit of studying, reviewing the problem, undertaking all the exercise. Most of us may have spent less than 5 minutes to go through the entire problem and sit here to judge you. All right. So you are at that distinctive advantage of taking us through the facts and the law. So it has to be very, very organized, your approach. You must first always take the jurisdictional arguments and then proceed to go with the main contentions. You can't just mix the two up and plead whatever you feel like, right? There's a certain structure to arguments which you must confirm. Number two, and this is something that I've been repeatedly requesting. We do matters where they are, where we are expected to know the facts. The judges already know the law in most of the cases, but you are expected to know the facts. You cannot afford to go wrong on the facts, right? When my brother Justice Khattar asked you a couple of questions, 2 or 3 of you were fumbling on facts, the date of arrest. I mean, for heaven's sake, you're arguing a bail. You have to know the date of arrest. You have to know the date on which charge sheet was filed, right? Similarly, there's something which is called a general awareness about the law, about the scheme and structure of the law that operates. While you are challenging the constitutionality or virus of a particular provision, that's fine. But you must also understand the fora that you are before, what you can plead, what you cannot plead, what can be agitated, or how is a prayer supposed to be worded in typical situations. There are so many drafts. Your internships and so many experiences that you may have garnered would have equipped you sumptuously to plead properly. Next thing, a big mistake is always citing an authority without citing the paragraph. My learned brother kept on asking you what is that paragraph number from which you are which you have relied on, and merely reproducing 170 180 footnotes is not going to help you, right? Especially in an international moot court. Indian speakers or Indian mooters for that matter are not very well looked upon with 200 authorities in your memorial without actually being able to justify what that authority stands for, right? You are citing a Papua Yadav case in a 32-year-old sentence and trying to equate that with a 1-month period of rejection of bail by at least 2 superior courts. I think that's not going to fly with the Supreme Court. So please be aware, how can you marry the facts of your problem and equate them with the authorities that you are relying on? Second most important thing is, I won't name which memorial it has, that discrepancy has come out from, but there are discrepancies where you have cited orders and not judgments, right? Please learn to make that distinction. Before these Honorable Supreme Court of India, if the law is not already laid down, then high courts merely have a persuasive value. Unless and until you can demonstrate that the judgment relied on by you is tailor-made to the facts which are there. Anything short of that, the Supreme Court may not even consider looking at. So while you are making those submissions, please be alive to all these things. Otherwise, a very decent effort. I wish you all the very best, right? Thank you so much. And thank you, my learned brother judges, for bearing with all the questions.
Always memorable to be back in moot courts. Sometime we were there that side, now we are this side. Okay, all the best, everyone.
Thank you, Your
Much
Lordship.
obliged, Your Lordship.
Thank you on behalf of the Moot Court Committee. Thank you so much for coming over this Sunday morning and afternoon, for coming in and leading competition. I'm sure the participants had a great time. And once again, thank you on behalf of the University of Calcutta and the Moot Court Committee for coming over.
Thank you so much.
Thank you, Mayank. Thank you, everybody.
Thank you. Bye-bye, everyone.
We'll just be sending across the scores. Okay.
Right.
Yes.
Thank you so much.
Thank you, everyone. Have a good day.
Thank you.